Hello, and thank you for joining us for the SLW Institute webinar, 10 Ideas for Managing IP Expenses in Lean Times. A recording of the webinar and the slides will be made available to all registrants, and the slides have also been posted on our website, and we will place a link in the chat. Feel free to enter any questions using the Q&A feature in the Zoom menu. We invite you to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Well, hey, thank you, Michelle, and welcome everybody to our webinar today. I'm Steve Lundberg. I'm principal at Schweigman Law Firm. I've been practicing IP law for many years and have been through a number of these economic cycles, one of which we may or may not be in at the moment. And I want to introduce our panel today. First going across from left to right, we have Andre Marais, who's a principal at the SLW law firm. Andre practices out in Silicon Valley, has had many, many years representing some of America's most innovative companies, and has done a large amount of portfolio management for those companies over the years, and has been through a number of economic cycles, and so has a pretty good idea of various different game plans for managing through these. So we're really glad that Andre can join us today. Next, we've got Pamela Huff. Pam is also a registered patent attorney, but principally focuses her practice on trademarks, and has been doing that for a number of years. Pam is also a principal with the firm Schweigman, and has been in practice many years, currently residing down in Texas and San Antonio. Drew Hirschfield was maybe joining us today. Drew had something that pulled him away at the last minute, and he's hoping he can get back in time. But Drew is former commissioner of the U.S. Patent and Trademark Office, and is also principal at the firm. And Drew focuses his practice on expert opinion work. And he did give us his notes today, so we'll share what he gave us. And then last, we've got Francois deVilliers, who's one of our principals as well. Francois has spent many years in corporate practice, and he was at Creative Labs and Plantronics. And so we're really glad to have Francois join us today. Francois practices out in California with our firm, and does patent work. Plus, he's also excellent in licensing, and in particular is a subspecialty, I guess you would call it, in software licensing and various different components of that. So with that, let's move into the presentation and see what we've got for you. So first of all, I want to put a disclaimer in here before we get started that we build this as 10 ideas, but we had so many ideas that we abandoned trying to label them 1 through 10. There's probably 30, 40 great ideas that, or serviceable ideas. I don't want to prejudge our ideas, but good ideas that we have to share today. So it'll be 10 plus 20 probably by the time we get through here. So before I talk about this slide specifically, I just want to say, why are we here today? Well, everyone knows there's been some layoffs in the tech industry, and usually that trickles its way down into the patent and trademark departments of various IP departments of corporations, and then folks start to look around for ways to save money. We know the semiconductor industry is, goes through cycles, and it may be in a down cycle right now. And economy in general, where it's a little uncertain whether it's going sideways or down. I just read something before the presentation started today that people aren't even sure whether the economy is in a recession or not, but folks are looking around right now to be prepared for it. So we thought we'd get out in front of that and share some ideas of what we see people do and have done in the past whenever they're trying to save some money in the IP area. So some of these ideas are just always good ideas, and some of them are maybe more short-term fixes for saving expenses. So we got three, I guess, big buckets of things that we'll talk about today. I mean, delay, various different ways to delay in order to save expenses. We'll talk about that as a category. And then counterintuitively, sometimes expediting things can actually save money. And so we'll talk about how to expedite and save money at the same time. So speed things up and save. And then finally, you've got all the various different ways that you can manage your portfolio or your processes or your relationships to trim expenses and to become more efficient. So with that, I want to turn over to the next slide. And this is Drew's Hirschfield slide, and I'm going to present it. I wish Drew was here because he'd do a much better job than I will. But Drew shared, with us, with the panel here, that at the USPTO, and I think some folks probably realize this, surprisingly, during downturns, they typically don't see significant reduction or any reduction at all in the number of newly filed patent applications. But what you do see, and what they usually always see, is the maintenance fee payments go down. So first place people look to save money, especially in larger corporations where they've got huge maintenance fee budgets, is to cut out unnecessary maintenance fee payments. So that's the big picture. And I think in private practice perspective is that's typically what we see, generally because your IP generated today has to be filed in a timely fashion in order for it to be preserved for future competition, for your future business. So you've got to keep maintaining your filings in order to come out of these recessions in a strong position. So you cut things that are no longer of value, that are legacy patents or trademarks, and you preserve your ongoing, filings. So with that, I'm going to move to the next slide, and then we're going to go to our next speaker here. And was this Andre? Or was this, I forgot who was taking.
Yeah, Steve, this is me. Yep.
All right.
Good. Okay. Now, Steve, thanks for that. Thanks for the intro. I think just circling back to Steve's slide where we had kind of delay. I think that the buckets that were two of the ones were delay and the other one was kind of manage. I think under delay, what we're going to be suggesting over there is just strategies you could do to not give up on any rights or cut costs long term, but these are just strategies to kick that can down the road a little bit, but more under the managed bucket. That's where we'll be discussing various ideas to really cut costs, by abandoning or being less aggressive in pursuing a strategy. But diving firstly into filing strategies, what we've seen a number of clients do during downturns is a few actions on kind of the front end here at filing. The first one is more aggressively filing US provisional patent applications at the patent office. I was just actually on a call earlier today with a client discussing this very option. So the advantage of filing a provisional as opposed to a utility patent application is that this can delay prosecution costs, because you're obviously delaying the time at which the USPTO is going to pick up the application and start examining it. And also it saves on USPTO charges. For example, if you're a large entity, the cost of the USPTO charges for filing a provisional are $300, where if it's a utility, you're looking at typically $2,000 range. So that's immediately a $1,700 saving there very often. There are some downsides, of course, to provisionals. It does it delays receiving the enforceable rights. But again, if you're not in a screaming hurry to have an enforceable patent, this is maybe worth delaying those expenditures. I think the one thing on provisional patent applications, though, is really that we advise is not to skimp on quality. So again, with a client I was talking to this morning, we're taking a specification, and actually we had 4 sets of claims based on this one product. And the initial plan was to file 4 parallel applications at the patent office. And what we're doing over there is basically taking that same specification, merging all the claims into that same document and filing that as a provisional patent application, which once there's greater visibility into budget, we can then at that point file US utility applications based on that provisional. But that's very effective, going to be effective particularly over the next year in probably saving them some money. But they do of course understand that our original strategy was going to file these 4 applications fast track, and that was going to increase the burn rate, but we're following the strategy now just because of the uncertainty. So again, first point, file provisional patent applications. The second strategy we're also encouraging some of our clients to do is to file PCT applications in the first instance, or even enter the US using the PCT route. So as opposed to filing your US application in the first instance, file a PCT application in the first instance. Again, this is with a view to delaying beginning of prosecution in front of the US PTO, and effectively you can delay any prosecution costs using the strategy for up to 30 months from that date. Again, the nice thing about the PCT is that it does give you options to immediately drop into national filings. You can file your US application off that PCT at any point you want. And the other advantage of a PCT is, of course, you're getting a search and examination report that you can optionally elect to respond to or not. If budget is going to be severely constrained, you might elect just simply to ignore the international search report and written opinion and not respond to that. Alternatively, another good strategy there is actually responding to the search report and written opinion. And if you can get a favorable determination in the PCT process, leveraging that into PPH, patent prosecution highway, at the US Patent Office or other patent offices. So again, PCT applications do really give you a lot of options for kicking the prosecution costs down the road, by 2.5 years. The downside is a PCT application, as far as official filing fees, is more expensive, and you're typically looking at $3,500 over there. But in a case of spending now to save later, it may very be well worth your time to spend that and money to spend that $3,500 now to basically reduce expenditures over the next 2 years, if that's what you elect to do. The cost of filing the PCT also can vary depending on which office you elect as your search authority, of course. The US is the most expensive at $2,000, but again, that if you are using the US as a search and examination authority, that can really be leveraged into moving along prosecution at the US PTO eventually, and actually saving costs because you're having to go less cycles with the patent office. EP is a little cheaper, about $1,800. And if you really want to save on the PCT filing, the Korean Patent Office, if you use that as the search and examination authority, is the cheapest at just under $1,000. But there's always strategy there about if you want to leverage the search and examination authority to reduce costs in prosecution down the stream. So anyway, that's just something to maybe discuss and consider. There are also a number of front-end actions, that we do recommend to clients, perhaps more aggressively, during downturns. Conducting more thorough or conducting more frequent prior art searches to evaluate ideas that are coming up and really making calls on that front. Francois, I think during your time in-house at Creative and Plantronics, did any thoughts on how you guys use prior art searching to make sure, perhaps
Yeah, I
kind of
think-
reduce your spend?
Yes, I think that there is, it's a good idea to do a brief prior art search initially, just to make sure that there's nothing that's dead on your invention disclosure. But I think there's also a limit there, and almost all patent applications get rejected, and you end up finding something to patent in them as well. So I guess it's a balance there, more of an initial review rather than trying to knock it out completely. Because if you try and knock everything out completely, then you're probably not going to end up patenting a whole lot.
Yeah, agreed. Yeah, and I think another issue really is sometimes we on filing strategies, using the mechanisms that are available to expedite prosecution, even though you're spending more upfront and you'll have a higher burn rate on your prosecution budget in the short term. We do see that you may well save on the long term. So if we're looking at achieving savings in your patent portfolio, I think the question you really need to ask is, look, am I looking to just are we looking to just decrease costs in the next 12 months to 18 months, or are we taking a 4-year window to look at, we want to reduce costs in the next 4 years? Typically during downturn, a lot of companies are saying, hey, we just need to cut costs immediately, quickly, and now, in which case delaying strategies are maybe better. But if you're taking a slightly longer term view, some of these expediting strategies, again, spending more to save over a slightly longer term, such as fast track, fast tracking your application, we typically find prosecution costs on the back end of that, recoup any fees you pay upfront to fast track the case, and sometimes even achieve savings beyond that. So again, that's when filing, something to consider is, if we're looking to reduce costs over the next 2 years, it may be worthwhile doing fast track. But if you're looking to save costs over the next year, maybe not so much.
And also, if you are tightening up on the number of filings, then for the ones that are marginal, do we file, don't we file, you can also consider defensive publication to create the prior art and freedom to operate. Defensive publication is, of course, much cheaper, and it still may help you provide some of the freedom to operate that you're looking for.
Yeah. Steve, so that's I think the main suggestions we had on the filing strategies.
Okay.
Yeah. So
go to the next slide.
Yeah.
Oh, wait, Pam. I'm sorry, we forgot
sorry.
to bring Pam in. So Pam, sorry about that.
No problem. I did have a couple comments, certainly on the trademark side too, because the trademark side offers some flexibilities, at least in the delay bucket. Going back to that first slide, that I think we don't see, of course, on the patent side. So in the US, particularly, the flexibility is to rely, of course, on your common law rights. And so it's a let's say a less risky, there's certainly some risk involved, but it's a less risky way of delaying. So you're not really giving up rights per se, but you're delaying the cost, the filing. And I would say this is particularly relevant in looking at the portfolio as to, say, slogans or maybe secondary brands, weaker marks, maybe marks that are borderline, descriptive. I think it's an easy way to delay. It may be that you eventually do want to file for those, but you're not looking at a 1-year time bar to file your trademark. So, I have clients that will, in the 08-09 timeframe, who actually incorporated this strategy and kind of kept with it and said, we're not really getting a lot of bang for our buck, say for a slogan or for a secondary brand. So we actually are going to rely on common law rights for those marks going forward. So that's one way that I've seen on the US. Now, I think it's much different, of course, on the foreign side, because so many territories, international territories, are first to file countries. So You know, you obviously have to be careful that you don't have, you know, the trademark squatters or any other type of interveners filing. So I typically don't discourage foreign filing. So there has to be a balance, of course, because so many foreign filings are based on your original US filing. So typically what we'll do, and I know we'll mention this on the patent and the trademark side going forward, is just really understanding your portfolio and understanding which marks are the most, or patents, right, are the most important to you. So that on the trademark side, you know, we go ahead and file in the US for primary brands and then move forward with fairly robust international filings where we may choose to delay again for secondary brands, for slogans and things like that. The other thing I'll mention, I think many people are already doing this, but, you know, relying on the Madrid to file, it's, you know, we've had a lot of debates on the trademark side as to whether it's actually cheaper to do the Madrid. I think probably in the long run it is. It's certainly, you know, with some of the Middle Eastern countries joining the Madrid, it has, I believe, will certainly prove out to be more economical. So I just, as a reminder, you know, to use that as a filing means, if possible, if the territories are ones that you can use for that. So anyhow, those are just some general comments on the trademark side.
Thank you, Pam. So I think we'll move on to the next category of ideas. And here we're talking about prosecution strategies. And Francois, are you taking this one?
Well, I can start off with it. I think that at least before the USPTO, it's very good to consider interviewing all of your cases. I think there is a lot of misunderstanding that occurs between examiners and applicants based on the written product, and it can be very useful to have a discussion to talk about the differences and about the examiner's position. And quite often there can be an aha moment there that can result in an allowance. And also, I think my approach is to make those interviews more of a collaborative aspect rather than so how can we together, examiner, find something that will satisfy you and satisfy me, and ask for the examiner's input. And I think that you know, that collaborative approach, it doesn't mean you have to accept the examiner's proposal, but quite often something can be teased out there, and that can be much more efficient than hammering back and forth with long office action responses and rejections. Another good strategy is to of course draft claims of varying scope to see if there might be some allowable subject matter that you can get to fairly early. Of course, if you do get a favorable international search report, or then you can consider using the patent prosecution highway in the US and other countries to hopefully get early allowance there. My experience with that has been that some countries will not pay attention to that at all, while others will. But it's at least something to consider.
Yeah, and I'll step in there. I think, you know, again, with a view to reducing costs and reducing cycles with the patent office, I think everything Francois there mentioned were great steps, you know, to take. You know, the other thing also, maybe this goes back more to filing strategies, but I think when drafting claims, really, you know, drafting claims with good diversity of terminology and limitations is a good idea, just to kind of tease out something that may be allowable. So really having a very deep set of dependent claims, you know, maybe something that you know, gives more targets for allowable subject matter. So, you know, one thing we're doing for some clients is really almost using, most of the quote dependent claims in your claim set of 20 as either, method or system claims, and not having very many dependent claims off the other independent claim types, just so that we can get the maximum number of dependent claims with different language and different angles and different terminology in front of the examiner, and hopefully, something there will be allowable or gives you more options, to amend from the claim set. So that's another good way to also, seek to reduce the number of cycles with the patent office. There are a few, steps you can also take during prosecution to really delay things. So the one is there's you can file a request for suspension of action for up to 3 months. Up to 6 months in total. That does require a showing of good cause, and for that to be successful. Another thing we do also see is the filing of RCEs plus limited suspension, which gives you suspension of prosecution for up to 3 months. Again, 3 or 6 months over there, could delay things for you, which may be helpful. Another strategy also when filing continuation applications, if you file that with missing parts, in other words, you filed your continuation without paying the fee, which will then trigger notice of missing parts, and in that way you can really delay prosecution, because the patent office won't pick up that continuation application and begin examination until you've paid the fees. That's another way just to buy a few months. All of those are not buying a huge amount of time. It's really 3 to 6 months in delaying examination. But again, if that's that may be sufficient for purposes of a particular client to have a budget squeeze in the short term, but anticipate things will be some money's going to free up later. So these are steps that can be taken at the US PTO.
And then
Pat,
go ahead, Andre.
I was just going to say, I don't know if Steve. Yeah, I was going to see if Pam had anything on the trademark side.
No, I didn't have anything on this particular slide.
Okay.
So, another thing I would add is certainly if you're at a final and you want to delay filing an appeal and not going overboard on your appeal brief, but just meet the minimum standard, typically that's going to kick something up into the a fairly long wait, and then you can bring that application back into prosecution once your finances improve. So that's another strategy that I've seen used.
Yeah, and then of course there is also the option to take extensions. The patent office does allow up to 3 month extensions for responses, but those can get expensive, particularly if you go to the 3rd month. I think the 3rd month extension fees are $1,400 or more. But again, depending on your financial considerations, that may or may not be worthwhile.
Yeah, if you're in the last month of your quarter and you need to push stuff out to the next quarter, it certainly works well. It does cost more later, but all right. I think Francois, you basically made all the points you want to, so we can move on.
Yeah, that sounds good.
All right, Francois, you want to talk about international strategy for us?
Yeah, sure. So of course, the international strategy on the patent side is very important for managing the costs because of the expense of filing in different jurisdictions, the ultimate costs of translations and annual maintenance fees, and foreign patenting can become very expensive very quickly. Of course, the first place to start for most clients will be filing a PCT application at the end of the priority year instead of direct national filings, so that you can have that delay there, and also give you a chance to assess the patentability of the invention and the scope of the claims that you are going to get. And I think that a case might be identified as an important case when it's filed, but that doesn't mean automatically that you should file it in national, regional phases at the end of your PCT. I really believe in a considered approach. Take a look at what are we likely to achieve? Is that valuable coverage? Does the based on our US and PCT search reports and office actions, what are we going to get, and does that have actual licensing values? It's also something to consider is the size of the market for your different foreign applications, and how much are you spending for each dollar of gross domestic product. So in the US, you are spending every dollar of your patenting expense buys a large GDP. And so it's kind of a sort of normalizing factor, whereas as other regions and countries, patenting is more expensive and the market is smaller. So think about, would I rather have more US patents and rather than one foreign family? At least something to consider. It's also think about what is the goal? What is your goal for international patenting? And if on your portfolio, if your portfolio is primarily defensive, then every legitimate competitor is going to be participating in the US market, right? So no matter where you get sued, if you've got US patents against a competitor in the US market, then you can always use the well-established litigation system in the US. Of course, if you're ultimately going to be licensing, then you will want a more broad international portfolio. But even then, I would say, be considered and save the international patenting for the valuable cases based on your considered assessment at the end of the PCT period. But again, this is going to depend on the specific facts and on the technology area. Of course, if you're in the pharmaceutical field, you're going to be filing foreign a lot more than some other technology fields.
Well, and Francois, I was going to mention on the trademark side, much of what we consider is very similar, I would say, to what you mentioned on the patent side. I mean, the filing internationally on the trademark side is, of course, much less costly than filing patents, but it still can get very expensive, especially if you're filing in, I would say numerous, but literally, we've done filings with 20, 30, 40, countries. It's also an easy place to pull back just slightly. Are these territories really as important as we think they are? One of the things we've done, and this really kind of goes under the management bucket, I would say, from the first slide, is setting out, especially for the clients who have enormous international portfolios, is really setting out tiers. We call them. You can call them whatever you want, but we say, picking your tier 1, tier 2, tier 3 countries. As a first step. I would say, it's easy, especially on the trademark side, where you have so many filings and so many international registrations issuing, and it's easy for a portfolio to kind of get out, I don't want to say out of hand, but where you don't truly understand, or the client doesn't truly understand what is actually in my portfolio. So I say this is a great opportunity, again, to take a step back and say, I really need to understand, right, what we have and where we have it, and what countries are really important to us. Again, looking at tier 1, tier 2, tier 3, some of the things that we talk about with clients are, well, and also relate to the fact that with trademarks, you don't have to have use in many of these foreign territories in order to get a registration. So, we look at things like how high is the risk, right? So there may be certain territories where we've seen an inordinate amount of trademark squatters depending on the industry, right? I mean, it could be Asia, but it also could be South or Latin America. And so that's one of the things we're thinking about in establishing those tiers. The other thing that we really talked about more heavily really over the last year or two has been, I think everyone has always, on the trademark side anyway, China has always made a lot of sense. Oh, absolutely, let's get a registration in China. But the registration process of many of you may know has become increasingly difficult. So while the cost to file in China is not very high, the process overall has become quite expensive because of the changes in prosecution and kind of what we're seeing in some of the things that, like letters of consent, I mean, things that where we used to be able to overcome cited references that we're no longer able to use in China. So I've had a number of clients recently say to me, we're really not going to go into China, right? So we're spending, 20 or 30% of our trademark budget dealing with these issues with, the prosecution in China, where it's really not a territory that we're going to go into. So they've actually pulled back and said, this is not a place where we are going to have our trademark spend. So we've adjusted, again, these tiers. Okay, so maybe China is not a tier 1 country, but a tier 2 or tier 3. So then when we take a step back to, the comments I made on filing strategies is, when we look at a mark, is it a primary brand? If it's a secondary brand, let's say, or a slogan, then we may want to delay. But if we do want to file, then we look and say, well, we're only going to file that in our tier 1 countries. We're not going to dive down into tier 2 and tier 3 as far as the importance. And so, the tier 1 may only have 5 countries, whereas tier 2 and tier 3 may have 15 or 20 each. So it's an easy way to manage how much spend is dedicated to to each of the marks. And typically, we don't delay. Of course, when it comes to, we don't worry about delay when we're talking about tier 1 countries. So in any case, it's just an easy way or an easier way to manage. And it's something really that I think for especially on many of the larger portfolios that we should be doing anyway. I think what happens is, again, the portfolio can get a little unwieldy. Countries have been added, marks have been added, and I believe, especially with some of the comments Steve made on the economy, it's really a good time because I feel like a lot of my clients now have said, okay, I am going to spend the time, right, to take a look at this and to establish the importance of the countries I want to be in and why I want to be there. And okay, I'm ready to take the time to do that. So it's actually presented a good opportunity, I think, for us to better manage and help clients better manage their portfolios.
Thanks, Pam.
Sure.
Yeah, Stephen, I just had just a few observations as well, or maybe anecdotes. We had one large internet client as a company, and I think they very much looked at Francois was talking about a defensive posture. They did, but that really drove their international filing strategy to the extent where they were more looking at where their competitors were active rather than where they were active. So in some countries, this particular client dominated, and really some of their competitors just couldn't get into the market because of various networking effects and other they just had market domination. In another country, they had actually ceded that country to the competitor. That competitor was totally dominant in that country too, and their filing strategy was actually kind of counterintuitive, where they'd file less in country 1 where they had market domination because they really didn't see that their competitor would have very much damages exposure there, and where in the country where they weren't even active, they would file a lot of applications there just internationally because that's where the competitor was, and they had had the greatest exposure. So I think one thing to look at when assessing markets is not looking, exclusively at where where your markets are, but also looking very closely at where your competitors are, have got big market penetration. I think it's also very interesting to discuss too with patent litigators about which countries you should file in. If we look at the Apple Samsung litigation, there were kind of concurrent litigations happening in Australia and Canada and in Europe, but jurisdictions such as Australia and Canada are relatively cheap to file in, are quick to cheap and litigate in, and sometimes if you're in litigation, leveraging those wins in those jurisdictions back to the US can be helpful in kind of settlement negotiations. But overall, I do agree with Francois, and I think sometimes we have seen some large clients more out of, I think, maybe fear of missing out, being very aggressive on foreign filings, and then doing mass abandonments where it kind of turns out that they were a little too aggressive there. One final thing I would recommend is to maybe for clients is to work with your US counsel to actually reach out to local firms in different countries to see what options are available in those countries for delaying or reducing costs. A number of countries have options for taking extensions that are really inexpensive, and each country is different, and there may be some unique mechanisms available in those countries to really help you keep your costs down in the short term. For example, for European filing, we have some clients who, as opposed to going for a European application, decided that if they had, Germany, that was sufficient, and in that case may elect to file, just a German national phase as opposed to a full-blown European application, and in that way kind of reduce their expenditure on foreign filing as well. Okay, but I think that was all
Very
I
good.
add. Yeah.
A lot of good. I think we've passed 10 ideas by now. So I think we've met our minimum duty to the audience. So let's move on to our next slide, and portfolio hygiene. Pam, were you going to take this one?
Yeah, sure. I'll start us off. No problem. Yeah, I mean, in this, on the trademark side, this really relates back to the comment I made previously about ideas on how to manage a portfolio in this tiered approach, right? So obviously trademark renewals are going to vary by country. Some are much more from a cost perspective than others, but that, again, if we're looking at tier 1 countries, typically what we've seen from clients is, well, it's okay with me if the countries are more expensive. If they're tier 1, they're the most important to me, and I'm going to file those renewals regardless. Whereas the tier 2 and tier 3, we've developed charts with costs and things for the client to think about. Again, it's a tier 2, it may not be as important. If the country is particularly expensive, then it's an easy place to cut. Now, I say that thinking at the same time about which, again, going back to kind of managing which marks are the most important. Of course, trademark portfolios evolve over time. And I just met with a client who said, at one point, this mark was very important to us. It was considered a primary brand. But we really have, over time, found that other marks are more important to us. And so this is a mark that we will be phasing out. So over the next year or two, we can really look at, even if it's a tier 1 country, we can look at not renewing this. So I think the thing that we're really focusing on is avoiding kind of what I've heard you all mention too on the patent side, is being too aggressive with the cuts. In 08 and 09, I had a number of clients who really were so aggressive with their cuts that they came out on the other end really regretting some of the marks, some of the decisions they made with marks that they chose not to renew. Now, marks that they spent considerable amount of money obtaining, they didn't renew it, and then they realized, well, we really should have taken a breath right before we made that decision. So I feel like, assuming we're headed into another recession, I feel like talking with my clients now, it's a little bit more measured approach as to what they're going to do as far as maintaining marks and making sure their portfolio is in order. Again, these are things that really we should always be doing. I think getting, again, this type of economy gives us a good opportunity to get a client's attention, right? And to circle back and say, okay, yeah, I'm going to sit down and I'm going to really think about what's the most important to me, because renewals is a very logical place to cut. We have clients that in good times are renewing everything when frankly, they're renewing marks that aren't truly, that important to them. So anyhow, that's the comments I really have on that. I think, again, understanding the portfolio, managing, taking a step back and making sure the decision to renew is the right decision, for this particular time.
Thank you, Pam. Andre? I think you're on mute, Andre.
I also think I'll jump in quickly while Andre's here. This is an opportunity for some analytics. Steve, I don't know if you want to mention the use of analytics to assess your own portfolio, to see where your clients are patenting, and to make sure that you are kind of again focused in your portfolio.
Sure. Let me jump in on that for a second. So there's a couple of different approaches, to apply analytics. One of is, fully automated analytics, where, you're essentially plugging in classes or keywords that group patents into clusters, and then allow a comparison of various different companies in a particular industry sector in terms of which companies, have the strongest portfolios using automated analytic assessments. And those can be helpful to, perhaps you look at your portfolio, you're in a really dominant position according to the analytics. You've got, a really strong position. There's more opportunity perhaps in that area to trim out the fat that you don't need, whereas maybe you're weaker in another comparison to your competitors in a different, segment of your business. And maybe there you go more carefully go in and make sure that you're not trimming anything that might have some value. So, the automated analytics that you can generate out of many of these analytic systems these days are cheap and easy to do and give you some interesting and actionable information at a high level. Now, if you really want to look, at where you sit in a precise way or a really, reliable way, you really have to get into looking at your claim coverage eyeballs on, because these analytic systems are just not capable of, they're not infringement detectors. They're guides to look for infringement, but when it comes down to it, they can't read claims on products. They can't read claims on your competitors' products or activities. So there we have tools that, for example, Schweigman uses that our ClaimScape tool, aka ClaimBot, that facilitate a very efficient assessment of a portfolio with eyeballs on, where you're really looking at the quality of each patent with a judgment of a qualified patent attorney as to whether it's an important patent or not, based on the claim scope assessment that you do, and then maybe read those claims on competitors, or at least get a sense of how broad they may be in your industry. Those types of hygiene are much more labor intensive, but everybody should be doing this episodically from time to time. You can't do that every day. It's expensive, but at least once every year or two, you really ought to be going through your portfolio and finding your gems, finding your best patents, and figuring out which ones are not worth anything anymore. I often say, it's there's the patent landscape is constantly evolving. Your patent that was not important at all yesterday becomes your most important patent 10 years from now, and the one that you thought was really important today is turned into junk, even a month later when you find a killer piece of prior art. So you have to really constantly be reassessing that. So that's a little bit of a look in terms of doing the hygiene. Now, in times of downturns, it's probably a good time to take on that kind of a project, as long as you've got enough budget to do it. But a lot of this work can be guided by the in-house team, and has to be guided by that team. So they put a little bit of extra time aside to look at their portfolio. That could be tremendous, could pay off a lot, not only in terms of getting rid of patents that are valuable, but finding the ones that are while they're still in flight and making changes to your prosecution strategy as the patents progress through the system, so they come out in a stronger position. Andre, do you have any thoughts?
No, Steve, I think you checked most of it there. I mean, I think just the point that, this kind of, ranking and rating and understanding your portfolio, and I totally agree, it needs to happen, with a certain frequency because things change so dynamically. But that's really the cornerstone to, managing the portfolio and performing, this portfolio hygiene, which is really, cleaning up your portfolio, as it were. So once you've kind of figured out which are your most valuable assets, or even put them in different buckets, or given them a ranking, you can then take various actions on, the granted cases. Do we pay the annuities or maintenance fees or not? On the pending cases, for our high value ones versus our lower value ones, what do we, how does that impact prosecution, and that type of thing. And then also, even ranking and rating your disclosures based on a set of metrics. And Francois previously mentioned over there, if something is, it may be very novel and very patentable, but if there's limited business value or defensive value in filing it, do a defensive publication, or just kill it, or maybe you have the option to pursue trade secret protection as opposed to patent protection. But really having a defined set of metrics that you use to rank and rate your portfolio. And I also totally agree with what Steve said. A lot of it just does need, there are obviously automated ranking tools out there that look at a number of factors, and those are helpful as a data point. But again, we'll often find that those tools will rank something highly that's not that valuable, and vice versa. But it's still, those automated tools are, it's a data point too that you can use. But yeah, that's all I think, Steve.
Yep, and I'll put just one last point on, and we'll move on. Let's see, we're time-wise, we've got about 6 minutes left. But I mean, I think there's a tremendous reluctance typically to give up on an asset that maybe you're prosecuting a case and the claims have been significantly narrowed. And, there's a really strong bias to sort of complete that, get it allowed and get it issued. But, this, if you're driven by, stats and actual by hardcore business decisions, those cases really should be dropped as quickly as you can get rid of them, because they just drain cash. Now they go into your issued patent portfolio. They're not worth anything the day that they're issued. And then they just become a drain on your company for maintenance fees. And then someone has to go back and look at that thing, 10 years from now to figure out it's, for the second time that it wasn't worth anything to begin with. So that's my last point on that. So moving forward, let's go to our next slide.
Steve, I think we got one question about, I think Jonas asked, is it time to consider licensing or selling IP? I think for portfolio hygiene, John, a great question. I think there may be cases that, according to your metrics, are not valuable to you, but may be very valuable to someone else. So that's also, these are, when doing portfolio hygiene, it is good to, as opposed to just abandoning a case, figuring out, okay, are we going to sell it? And, obviously there are a number of larger companies that do this routinely. I mean, IBM, is continually evaluating their issued patents and, putting ones that they deem of less value onto market. So absolutely.
Yeah, and I think that it's good to note there that there are fairly efficient markets for putting those patents up for sale. So it's gotten easier. There are a number of folks out there that will handle, companies that will handle these sales, and they're happy to take your phone call.
Sure.
All right, next slide. All right, so this one was this going to be Pam? Were you going to take this?
I'll start us off. I have a very quick comment, so easy on the trademark side. The only thing I was going to mention here was that one of the things that we've seen on the trademark side is that, especially for portfolios that are incoming, is that there may be a large, maybe very reputable firm, international firm, that's being used for the trimmer portfolio, where like a main office then outsources to other foreign associates. And what it basically does is add a layer of expense. So one of the things that we've done, we typically is that, and especially in times like this, is really look at what firms are being used as foreign counsel, make sure that we're not doubling or tripling up on, foreign associate fees. So that's one of the things we really try to keep ahead of all the time. But it is one of the things that at this time, especially in a bit of a downturn, that we pay particular attention to. But that's all I had on the trademark side.
Sure.
So on the patent side, in terms of the firms, I think one thing to consider is, are you dealing with a specialist IP firm or with a general practice firm? And especially, the brand name general practice firms, they're fine attorneys, but there are internal billing pressures at those large firms. If you're a patent attorney doing prosecution and you're competing with corporate attorneys or litigation attorneys that are over $1,000 an hour, that's going to put a lot of pressure on you as a patent prosecutor, and result in many cases that we've seen much higher fees from those firms. So my preference is to find a specialist firm to do that, to do the IP work for you. It's also, I think, worth considering how the firm is run in terms of its systems and procedures. The use of automated tools for a review of patent specifications. Catch as many errors as you can before they get to the patent office, so that you're not stuck with having to do certificates of correction or with some antecedent basis problem in litigation. In terms of the relationships, I'm a firm believer that in terms of the quality of the work, it's individuals more than firms. Take a look at the team, who's on the team, and once you've established trust, then it's pick the firm based on the attorneys rather than just the brand name of the firm. In terms of procedures, it's good for clients to have procedures, outside counsel procedures that the firm can follow, but also be mindful of that creating unnecessary obstacles. Lots of outside counsel want to review a lot of the work product, but that can be very inefficient if the in-house counsel gets overwhelmed with other things. So maybe set a threshold. The top 10% of the cases will have hands-on review, but for the remaining 90%, use your trusted counsel to proceed, and on the assumption that if there's anything that needs your input or authorization, that they will come to you for that. That's it for me.
Thank you, Francois. I was going to lean into that a little bit with an analogy that I often think of when it comes to hiring patent counsel or any professional. In drafting patent applications is a bit of an art form. It involves creativity. One word can sink the ship in the wrong place, can sink the entire patent. So, if you think about your patent counsel, your group, you're hired as an orchestra, you can imagine that you cannot get top quality music out of, average musicians. You have to have top musicians, and then you're the conductor, but you can't micromanage how they're playing their violin or tuba or whatever it is. You have to get really good people that can perform at top level, and you're not going to get that by micromanaging. You can put 1,000 processes in place and you can check everything 50 times. You're not going to get those musicians to play at a top level unless they've got the talent or the training, the skills to begin with. So I really think a lot of companies overdo the process, all these different things they generate for process. A lot of times they don't really add much value because you cannot compensate with process for missing talent. And so that's just something I've observed over the years. You can take it or leave it, but on to the next slide.
Yeah, well, I guess one final comment there is that it's very tempting to look at a cost per patent and require a fixed fee or a cap for your outside counsel. That's a way to control costs. But there's also, it can be a double-edged sword as well, because there's a kind of free market within the law firm for associates and for people who want to be on the team. And if you're the client who it has really squeezed the costs down to almost nothing, then the best associates or the best attorneys might rather go and work on another client that is less focused on the per unit cost as opposed to the quality of the product.
Yeah, we see that at Schweigman frequently. So we should probably move on and wrap up because we're pretty much over time already. Quick, just 30 seconds, outsourcing. There are some things that corporates can outsource to save money. There's also things that law firms can outsource. Certainly, we all know most people outsource renewals. There's usually a lot more fat in those renewal fees that you're getting charged than most people realize. And it's always good to take a look at that if you can, because there's millions sometimes of dollars that could be saved over a period of time there if you really drill into it further. Certainly, you can outsource, your back office, and a lot of people do that. So that's sort of a standard strategy. Let's move, and there's automation tools now that can really also increase your efficiency, which are a good investment. Next slide. I think that's it. Okay. So anyways, are there any questions? I don't see any questions in the Q&A. So any final comments from any of our panelists before we wrap this up?
I'll just close with a Go USA chant.
Yeah.
Yeah.
Is that starting right now, or is that in another hour? When is that soccer match?
I think it starts right now.
That's it. Okay. All right, everybody, let's go check out some soccer. Francois, were you going to say something?
Oh, no, I just looked at the questions, and Joan had a question about what clients can do to reduce the amount of attorney time for drafting or processing of office actions. That's really going to depend on the individual inventor most of the time. Some inventors are very involved in the patenting process and can help you identify the novel aspects, and other inventors aren't. It's difficult to put in a process for that because most of the inventors are so busy, even if they are interested, that trying to have a process to get assistance from the client can also be kind of cumbersome. So yes, the client can help, but maybe just on an ad hoc basis.
Awesome. All right. Well, I'll want to thank everyone for hanging in there with us through the presentation, and hope we delivered some valuable information. And I'll turn it back to Michelle.
Thanks, Steve. Thank you for joining us, everyone. And thank you to our speakers. Please keep an eye out for future webinars from the SLW Institute. Thank you again for joining us, and be well.